Okay. Well, greetings, everyone. I'm Amanda Miller, Associate Director for the National Consortium for Data Science, also known as NCDS. It is my pleasure to welcome all of you to our October DataBytes event, The Risks of Facial Recognition Technology, Dismantling the First Amendment Defense with Talya Whyte. Before I introduce our guest, I'd like to remind you that the goal of DataBytes is to share developments or new perspectives in the field of data science. These events often highlight work happening in industry and provide a pathway to connect our friends in industry and occasionally in law school with academia. We design NCDS events to build community. However, we also respect the limited time of our speakers. So it is with that in mind that we have disabled the Zoom Q&A for attendees. Our chat is also disabled to allow Talya to present without distraction, but never fear, we do offer a place for you to share your comments and questions. All comments and questions should be uploaded to Easy Retro, which is our crowdsourcing Q&A platform. Our Q&A will take place toward the end of our time together. My colleague will drop the Easy Retro link in the chat now, and you are welcome to add questions throughout the event. To add a comment or question, just click the plus sign at the top of the appropriate column. Type in your question and press the save button. And we'll go over these instructions once again when we launch the Q&A session. But please note that Ms. Whyte will wait to answer the questions until the end of her presentation. I'll add that we would love to continue this conversation or any ideas that are sparked today in our listserv. So do feel free to DM either myself or my colleague Jayshree Jagannatha or Kendra C, and we'll be happy to add you to the community. So with the housekeeping behind us, I am excited to welcome our speaker, Talya Whyte. Talya is currently a third-year law student at New York University. She is a 2023 Google Legal Scholar, a student fellow at Engelberg Center on Innovation Law, and an NYU Cyber Scholar. I am excited that she has made room in her busy schedule for us. So without further delay, I hope you'll join me in welcoming Talya Whyte.
Thank you so much, Amanda. And hi, everyone. Again, my name is Talya Whyte. I can't see your faces right now, but I'm really glad that you took the time out of your day to be here. As Amanda said, I'm a third-year law student at NYU, and I'm interested in the intersection of new technology, society, public trust, and digital rights. I've been fortunate enough to have the opportunity to do research and work on a number of interesting areas of technology law. Last year, I worked with a civil rights organization to develop and evaluate options for deepfake legislation as a part of NYU's Technology Law and Policy Clinic. I was formerly a student fellow with the Information Law Institute's Privacy Research Group and a student fellow with the Engelberg Center on Innovation, Law, and Policy. I'm also an alumnus of the Knowing Machines Project, a Google Legal Scholar, and an NYU Cyber Scholar. And today I'm presenting on a technology which I find incredibly powerful and frightening: facial recognition technology. Clearview AI, a privately owned US-based company that produces facial recognition tech, has been arguing that some part of its conduct should be First Amendment protected speech as a defense in various lawsuits. If courts were to accept this argument, it would set a dangerous precedent for a few reasons. As I'll show today, these defenses are ungrounded in common sense or the legal jurisprudence. Further, What Clearview wants is to immunize itself from liability, both from lawsuits and regulation. If the company succeeded, courts would have a heightened standard of review for actions of the company and regulation affecting the company. This would limit ways to control the conduct of Clearview and other companies like it. It would also create a major obstacle to regulating and protecting the public from the many harms and risks of emerging AI technologies. In a world chasing the tail of AI hype by diving into indiscriminate and invasive data gathering, this case could set a dangerous precedent. And if you could go back to the previous slide, the roadmap slide. Thank you. I'll start off by giving a little bit of background on Clearview, how facial recognition technology works, and the dangers inherent in it. Next, I'll talk about a few legal claims the company is facing. Then I'll present a case study of the Renderos case, a California case where Clearview recently deployed their First Amendment argument. I'll explain the Supreme Court case they rely on to make that argument, which is Sorrell versus IMS Health. Finally, I'll explain where their First Amendment argument breaks down and why it should fail. After that, I'll give a few takeaways, and I'll hopefully have some time at the end for questions. Next slide, please. Clearview AI is a facial recognition technology company founded in 2017. Clearview developed a facial recognition database by amassing people's images online without their knowledge or consent. Per their website, their database includes, quote, 30 billion facial images sourced from public-only web sources, including news media, mugshot websites, public social media, and other open sources amassed by searching the open web, end quote. They claim that they, quote, cannot and do not search any private or protected information, including private social media accounts, end quote. Clearview licenses its technology to law enforcement and government agencies. In May 2023, Clearview's founder reported that the company was used nearly 1 million times by police in the United States. The company was prohibited from making its database available to most businesses and other private entities nationwide pursuant to a settlement agreement in 2022. And I'll talk a little more about that later. Users can input a probe image of someone's face to return matching photos and metadata attached to those photos if that information is in Clearview's database. Metadata is the data providing information about the photo. So this could include how the photo was created, the time and date of the photo, the creator of the photo, the location where the photo was taken, among other things. As I've touched on before, Clearview has received a number of lawsuits claiming violations of privacy and other rights. The company has routinely been using a novel First Amendment argument as a defense. Next slide, please. So Clearview's process can be broken down into 4 steps. First, Clearview scrapes photos from the internet. Scraping is a process by which an algorithm indiscriminately trawls the internet for information. Clearview has scraped, as I said before, over 30 billion images from the internet, from social media, YouTube, and other online platforms, secretly and without users' consent. Next, the company conducts biometric analysis. Biometric identifiers are body measurements and calculations related to human characteristics. They are the distinctive, measurable characteristics used to label and describe individuals. They are often physiological characteristics, which are related to the shape of the body. Examples include the fingerprint, palm veins, DNA, iris recognition, and facial recognition. Clearview uses the images and a proprietary set of factors to create a face print. A face print is a unique biometric identifier which can be used to match the probe photo to other photos in the database. It's important to note that the face print is not the image of the face itself. So you can think of it kind of like a map. Maintenance of the database involves Clearview's retention of some data. It's not clear from Clearview's website what exact information the company stores. Clearview says, quote, "We store personal information for as long as necessary to carry out the purposes for which we originally collected it and for other legitimate business purposes, including to meet our legal, regulatory, and other compliance obligations, end quote. They also list 4 categories of personal information they process. Identifiers. This can include information like your name, postal address, a unique personal identifier, online identifier, IP address, email address, account name, or other similar identifiers. Face vectors, also known as face prints, as well as the photos and their metadata. Government-issued identification, and internet or other electronic network activity information. My best guess about what the company actually retains long-term is that it's some combination of the face prints, the set of factors used to make matches, and perhaps the metadata attached to the photos. Finally, Clearview sells access to users who can input a probe image and return photos and metadata from the database. So in practice, Bob Officer, who is conducting an investigation and receives a piece of photographic evidence of someone's face, could pull out his Clearview app, feed the photo into the app, and return other photos of the person along with the metadata attached to these photos. Again, that information could be a link to a social media page, their address, full name, age, or other information. Next slide, please. As I mentioned before, facial recognition technology has some inherent risks and dangers. The first comes from the immutability or unchangeability of biometric identifiers. Biometric information about you cannot be changed. Biometric data in the wrong hands can be used to stalk, harass, or impersonate victims. Once that information is out there, it's out there, and you can't change your face. There's very little recourse for this breach of privacy. I call the second risk inevitability. What I mean is that it's functionally impossible to avoid sharing information about your facial geometry if you're a person in the world. Not only is the information being gathered online at breakneck speeds, but many places also use facial recognition technology on their premises, including airports, concert halls, and venues. Once it's been gathered, in most of the US, there's no meaningful opportunity to consent or opt out if you don't want your face in a database. The third risk is inaccuracy of the matches. Although Clearview's website says it's not a diagnostic tool and that police should confirm the identity of suspects using regular investigatory protocols, in most places, there is no oversight into how police use these systems in their investigations. If someone is inaccurately ID'd by Clearview, they might not have a meaningful opportunity to contest its use because they likely would not even know what happened. The final risk is bias. There is well-documented evidence of racial and gender bias inherent in facial recognition systems. It's very difficult, impossible even, depending on who you ask, to remove bias from these systems. Joy Buolamwini has a TED Talk called How I'm Fighting Bias in Algorithms, and it's a great place to start if you want to learn more about algorithmic bias. These biased datasets and algorithms are also used within a biased and racist policing structure. Surveillance technology is routinely used to squash protest and dissent and stifle political speech. To give a recent example, in the wake of George Floyd's murder, law enforcement agencies in Minnesota carried out a secretive, long-running surveillance program targeting civil rights activists and journalists. According to an article from the MIT Technology Review, the initiative reached beyond its publicly announced scope and used tools to scour social media, track cell phones, and amass detailed images of people's faces, end quote. The use of this technology is not hypothetical, and recently there have been some troubling examples of facial recognition use in the news. Next slide, please. Late in 2022, lawyers employed at law firms challenging Madison Square Garden's use of facial recognition technology were banned from the premises and placed on an attorney exclusion list. The scary part is, these individuals were ID'd and pulled out of the crowd by MSG's facial recognition tech. Guards at the venue knew the attorneys' names and place of employment. New York City used drone surveillance to monitor backyard parties on Labor Day. privacy advocates decried the act as a violation of New York's Privacy Oversight of Surveillance Technology Act, which requires the NYPD to disclose its surveillance tactics. New York State recently banned facial recognition in schools after a report found that the risks outweighed the potential benefits. And as recently as 2 weeks ago, privacy advocates were protesting the Philadelphia Phillies' use of facial scanning to enter their games. Next slide, please. Political activists have brought a number of cases against Clearview. For the sake of time, I won't discuss the details of the cases, but I'll focus on Clearview's reliance on a First Amendment defense. In ACLU v. Clearview, the plaintiffs were claiming violations of Illinois' Biometric Information Privacy Act by collecting photos of plaintiffs without their knowledge or consent. Clearview agreed to settle the case in May 2022. The settlement did 3 things. First, it permanently barred Clearview from making its faceprint database available to most businesses and other private entities nationwide. Second, it barred Clearview from selling access to its database to any entity in Illinois, including state and local police, for 5 years. And third, Clearview must allow Illinois residents to block their facial data from Clearview's database. As a note, a few other states have certain protections against Clearview's conduct. These protections do not result from the ACLU settlement. Rather, they come from privacy statutes passed by these states' legislatures. So, in California, Colorado, Connecticut, Nevada, and Virginia, residents may have the access to access their information, delete their information from the database, request that Clearview does not share their information, correct their information, limit the disclosure of certain personal information, opt out of profiling, etc. The exact combination of protections afforded to each state depends on the structure of their state law. Clearview AI is a consumer class action, also centered around BIPA claims in Illinois. As of late September 2023, Clearview was in the final settlement stages for this case. Renderos is the main focus of today's presentation. Next slide, please. In Renderos v. Clearview, immigrants' rights activists and community organizers sued Clearview along with local governments and law enforcement agencies that allegedly used the company's facial recognition app. The plaintiffs were particularly concerned because they regularly engage in peaceful protest activity. Their lawsuit alleges, among other things, that Clearview has illegally appropriated their likenesses and violated their reasonable expectation of privacy and their biometric information, making it possible for the government to exploit Clearview's technology to chill their rights to free speech and association. Next slide, please. The case is in its early stages because Clearview filed a special motion under California's anti-SLAPP law. SLAPP stands for Strategic Lawsuits Against Public Participation. So anti-SLAPP is intended to help defendants quickly dispose of lawsuits that chill their First Amendment rights. What exactly Clearview is claiming to be speech is a bit murky. My best sense from their briefing documents is that they're arguing that some combination of the creation of their database and technology and the downstream use of their technology by government agencies and police officers is speech. The First Amendment argument that Clearview is making in this motion on appeal is the same First Amendment argument it's made in all of these cases around the country to date. To make this argument, Clearview relies on a well-known Supreme Court case from over a decade ago, Sorrell v. IMS Health. Next slide, please. Sorrell was a 2011 case dealing with a constitutional challenge to Vermont's prescription confidentiality law. The law prohibited the sale, disclosure, and use of pharmacy records, which revealed the prescribing patterns of doctors by pharmaceutical manufacturers. This process is called detailing. Next slide, please. In Sorrell, the court breaks the detailing process down into 4 parts. First, pharmacies receive prescriber identifying information when processing prescriptions. Next, pharmacies sell the information to data miners. Then, data miners produce reports on prescriber behavior and lease their reports to pharmaceutical manufacturers. Finally, detailers employed by the pharmaceutical manufacturers use the reports to refine their marketing tactics to increase sales to doctors. So practically what this looks like is detailers will visit doctors' offices to persuade them to prescribe a particular pharmaceutical. They'll bring drug samples, medical samples, and provide the details and potential advantages of various prescription drugs. The doctors will ask questions and receive follow-up data. Pharmaceutical salespeople, like all salespeople, can be more effective if they know the background and purchasing preferences of their clientele. Providing that background information is what the detailing process is meant to accomplish. The speaker that the court identifies in this case is the detailer. Next slide. The Supreme Court struck down the law as an unconstitutional regulation of First Amendment protected speech. Importantly, the court held that, quote, the creation and dissemination of information are speech for First Amendment purposes, end quote. Although the statute targeted the specific detailing process where pharmaceutical manufacturers promote their drugs to doctors, the case has since been used to support the idea that data gathering, analysis, and publication are all necessary components of speech and are also protectable by the First Amendment. Clearview is attempting to evade liability for every part of the creation and use of its app, arguing that the conduct is within the scope of Sorrell's creation and dissemination language. There are a few key problems with this argument. Next slide, please. Thank you. So I have two issues with the legal argument. One, it's unclear what Clearview is arguing is speech. And two, Clearview's conduct is not analogous to the conduct in Sorrell. My main problem with the legal argument is the lack of clarity about what Clearview's so-called speech is. Clearview never explains why its technology is speech under Sorrell. The closest it gets is saying, quote, plaintiffs have brought this case to silence Clearview's and its law enforcement customers' speech about the identity of suspected criminals in aid of law enforcement efforts, end quote. So the company seems to be making the argument that by creating and providing a database to police officers, Clearview is speaking about the identity of suspected criminals. However, just calling a process speech and hand-waving to Sorrell does not make it so. In doing so, Clearview creates the creation of its facial recognition technology with its downstream use and muddies the water for anyone trying to do a genuine comparison of the two cases. A reader is left with no understanding of why this novel technological process should be given the protection accorded to constitutional speech. Later in the anti-SLAPP motion, Clearview says that its, quote, political mission is to aid law enforcement with technology that assists in identifying individuals that are suspected of committing crimes, end quote. Clearview later describes this act of aiding police officers as speech. These are just two examples of how confusing and conclusory their argument is. My second problem with the legal argument is that Sorrell's narrow holding does not cover Clearview's activities. The holding says, quote, speech in aid of pharmaceutical manufacturing is a form of expression protected by the free speech clause of the First Amendment, end quote. Clearview focuses on the case's creation and dissemination language and ignores the more direct holding. I think this is too broad a reading of Sorrell, especially since the case was decided more than a decade ago, before this kind of technology had taken hold. There are also key policy concerns inherent in Clearview's argument. First, the privacy implications of physicians' prescribing information being publicized are quite small compared to the privacy implications of everyone's face and other metadata being in a searchable database. In the Renderos case, the privacy concerns are extremely heightened. Prescriber information does not reveal personal information about the physician. On the other hand, Biometric information is extremely sensitive and should be treated as such. Think about the dangers I mentioned a couple slides ago: immutability, inevitability, inaccuracy, and bias. My other policy concern centers around the way the First Amendment is used in this case. The First Amendment should not be used to protect an invasive surveillance technology company at the expense of individual people. If a company violates people's rights in order to create and sell its product, it should not be able to invoke free speech as a get-out-of-jail-free card. Clearview's distorted reliance on a few words in Sorrell is inconsistent with this common-sense application of the First Amendment. Further, Clearview's conduct is not public, it's proprietary. How exactly Clearview's matching algorithm works is not disclosed. The company tried multiple times to bolster the importance of its technology by calling it important to the public interest, but it's only used by police. I'm not advocating for a wide public use of surveillance technology. I don't think anyone should use it. However, it is especially frightening that this powerful tool is exclusively accessible by a police state widely known for its abuses of power. Finally, as I've said, if Clearview is protected by the First Amendment, it would be more difficult to regulate their activity, either by passing a law or suing. This matters a lot because of the privacy and other concerns raised by the use of this kind of technology, as well as the fact that in the age of AI, very many companies rely on the creation and dissemination of information. All of those companies cannot be First Amendment speakers. Next slide, please. Some final takeaways. If Clearview AI was protected by the First Amendment, it and other technology like it would be more difficult to regulate. In an age of AI excitement and hype, AI systems being trained on our data are pervasive, and similar legal claims have been brought against generative AI companies, OpenAI and Microsoft, asking for damages. So there is lots of activity in this area. Generative AI is the new exciting tech thing, but this technology also has many of the same risks and pitfalls of facial recognition technologies. These risks include embedded bias, privacy concerns, and other concerns. It is also troubling to see generative AI used to spread mis- and disinformation and perpetuate privacy and dignity harms in the form of deepfake videos. If you don't know, deepfakes are images and videos that have been digitally manipulated to show someone doing or saying something that they have not done. They are also created using generative AI. If Clearview's argument succeeded, the thousands of technology companies which now use AI and machine learning, which are processes requiring the rapid creation and dissemination of information, might have a legally viable claim that their technological processes are protected speech. This corporate protection would come at the expense of individual people's privacy and other rights. That's frightening, and it's not the direction where our legal jurisprudence should lead. Next slide. Finally, I just put a couple of resources that I think are good starting points if you're interested in this area and want to learn more from a different source. And with that, I'll open it up for questions. And thank you for listening.
Thanks so much, Talya. That was fantastic. And it looks like we do have a few questions that have ended up on our Easy Retro board. And so if my colleague will go ahead and put that on the screen, we can have the Easy Retro board on view and you can work your way through those questions. But while she is doing that, I am going to just go ahead and get us started, and I will read out. Wow. Okay, this is a big one. What are your predictions on the future impact of new technology on the public in regards to individual human rights?
That is a great question. And
Great.
that is a huge question. I hesitate to make predictions, especially as someone who is not a technologist. What I will say is the steps that we take now in many spaces, right, as lawyers, as policymakers, as scientists, as technologists, will absolutely like shape that direction. So I think it depends on how much we center humans and individuals over profit and data gathering and extraction of our information. So that was a lawyerly, it depends answer, but I hope that the future is good. And I know that there are many people doing work to try to make the future good.
Okay, and I'm going to let you work your way through these other questions on the screen as you see appropriate.
Sure. Okay, so the first one, and I'll just read them out for you guys too. The first one says, I just wonder about how Clearview AI's models were trained and whether or not the content they used to train the models was paid for, licensed, etc. With that said, I'm glad to see that someone is looking into digital rights and public trust. Thank you. And thank you for your question. So I will also wonder how Clearview's AI models were trained. That information is not public. As for the licensing and like whether that content was paid for in a copyright context, which I'm assuming is the context of this question, I also don't know anything about how Clearview dealt with that. What I do know is some other generative AI companies who have been scraping images and amassing them and then producing outputs that have companies' watermarks. So Getty Images is the example I'm thinking of, like are facing litigation. So this is definitely a question that other people are thinking about. It's Getty AI versus one of the Gen AI companies, and I can look it up and send that out afterwards. But that's a good case to look into if you're interested in that. The second question, the argument that facial recognition is free speech appears similar to arguments to justify denying services to people based on religious beliefs. Are these lawsuits an outcome of the Citizens United decision? Okay, so I'm not familiar with the Citizens United decision. I'm in First Amendment law this semester, and we're learning about the Establishment Clause a little bit, a lot. And that's where either free exercise or Establishment Clause, that's where these religious arguments come in. I will say that other cases that Clearview cited to, I believe, were referencing the free exercise clause. But in their briefing, I can't remember any time that they invoked a specific clause. They mostly just like broadly hand waved to the First Amendment and free speech. The next question, how are ethics taken into consideration in this argument, such as technology ethical standards? Yeah. And I'm assuming you mean in Clearview's argument. So don't want to speak for whoever drafted their argument, obviously. If there was some consideration of technology ethics, I didn't see it in the argument. And that's all I know. The next question, how would the discourse around Clearview AI change if the technology were used for other purposes beyond law enforcement? I'm imagining systems that use facial recognition for efficiency and consumer something as airport facial recognition. Yeah, so I cabined this research and this presentation to facial recognition technology because it's such an extreme example. I do agree that like there are other uses for facial recognition. My argument is that these technologies should not be afforded First Amendment protection, right? I think that some of the fears that I mentioned are heightened in like a surveillance setting, obviously, but yeah, point taken that like these systems are used in many other contexts and settings. Okay, moving over to the red questions. From the AI practitioner side, what are the most important biases to look out for if we're working for a company that is trying to implement facial recognition technology? That is another huge question. um, and I want to cabin everything I say from here on out and for the whole presentation, really, by saying that I am not a technologist. So those technical answers, I would say like look to some of those sources I offered at the end where technologists are speaking on this. But the biases that have been pointed out in these systems are the same biases that exist in the real world, right? Which makes sense. I mean, the data that's being gathered is data about the real world. So the biases that come into these systems are biases in the real world. I mentioned racialized and gender biased, but there are others. The next question, do you see a future where facial recognition technology can be utilized in an ethical and legal fashion? Gonna answer this one the same way that I answered the first question, which is that I hope for, a useful integration of these technologies, if possible. Do I see a path there? I think what's important is that we put stops in place to make sure that like people are involved in building these systems who are affected by what happens with these systems. So maybe. Has there been any effort to tie the biometric data to protections that there are for health data? Great question. I do not know the answer. I'm going to make a note of that and look it up, though, because it's an awesome question. And the last one, are there spaces you know of that support conversations on legal applications of data science between lawyers and data science practitioners? So first I would say like this platform that we're on right now. So this has been an awesome opportunity for me to present research that ties into both things. Like I said before, I've done work with the Engelberg Center at NYU, Center on Innovation Law Innovation Law, and they do a lot of work also connecting technologists and lawyers. The Knowing Machines Project, also at NYU, has published a bunch of research on this topic. And I have one more that, Tech Policy Press also publishes a lot on law and technology overlap. So those are just a few. And I think that's all of the questions. Am I missing any?
I think you've got them. And we do, as Jayshree pointed out, here we are. We have one just pop up. Great.
Okay. What do you think is the role between law and innovation? Can law inhibit innovation in tech spaces? Yeah. So I'll answer your second one first. Yes, absolutely. Law can inhibit innovation in tech spaces. And I think that that is okay sometimes, right? Like if innovation is coming at the expense of people's rights and safety, then I think that like that's in a just world, that's where the law comes in, is to protect people from runaway innovation. The role between the two, I mean, I think the framing that I just offered puts them at odds, right? But they aren't always at odds. Innovation is very forward thinking, and law is more focused on precedent. So there's a tension there. But yeah, I think that law is used as a protective mechanism when technology is moving too quickly. Another question just popped up. Assuming Clearview wins this argument in Renderos, how could a future facial recognition regulation survive heightened First Amendment scrutiny? What factors would a court weigh in that analysis, do you think? That is a great and very specific question. Yeah. So in order to survive heightened scrutiny, the government would have to show that they have a compelling interest in passing the regulation and that that interest is narrowly tailored. So to answer in a lawyer way again, it depends on how broad the regulation is, how much behavior it prohibits. So if the lawmakers wrote the statute in a way that was narrower, it might have a better chance of narrower, meaning it doesn't prohibit so much behavior, then it might have a better chance of sustaining itself against heightened First Amendment scrutiny, right? But this is all, especially with today's court, like, who knows? I mean, also the rights that the court would find, unsure. The next question, I don't know anything about the Sorrell decision. How sure are you that the Supreme Court will not apply it in Clearview? I am not sure at all to answer that question. No clue. How might Clearview's argument impact the viability of current or future deepfake laws? Great question. Another complex question because of the interaction of constitutional rights and scrutiny levels, and especially where constitutional rights are in opposition, as is often the case with the First Amendment and privacy. So the argument, I don't know. If the argument was accepted, it could limit the scope of the behavior that deepfake laws could regulate or prohibit. I hope that's a helpful answer. I know it's, again, very couched, but it's a fraught and confusing area of law. Have there been any similar arguments defending use of new technology in the context of surveillance and law enforcement? For example, fingerprints, the data services that collect data on individuals, such as where they've lived, and DNA. They've been able to collect usable DNA from footprints on the beach. Whoa, so-called eDNA. That's wild. Off of the top of my head, not that I can think of. Like I said, there have been some arguments in the copyright and space about, scraping platforms infringing on people's copyrights. But I don't know of any other ones. I should look it up after this presentation. And then, could you share the last slide again? I missed the third resource. So I can just read it out to you. The last resource is How I'm Fighting Bias in Algorithms by Joy Buolamwini. That's Buolamwini, and that's a TED Talk. I don't think I missed any questions here. Oh, yes, there's one. Is the Pandora's box a valid legal argument? I'm terrified of what happens next if Clearview is successful. Deepfakes are protected speech next. Yeah, so this is the worry, right? This is the worry. So is it a valid legal argument? That depends on what lawyer you ask. Is it, and also what court you're in front of. I do think it's a reasonable policy concern. Like, it's something that I worry about deeply. Whether it's a valid legal argument, that's above my pay grade. I think that's all of the questions.
Yeah, I think you've covered it. Talya, you have done a fantastic job today. Thank you so much for sharing this insight and your perspectives. Deeply appreciate it. Folks, I wanted to let all of you know that we will be sharing Talya's slides as well as the recording from today via email. We'll send it out to all of our registered attendees for this event. And I want to give a huge round of applause to Talya for presenting DataBytes this month. Very much appreciated. And I want to call your attention to the chat. My colleague Jayshree has dropped our evaluation link in the chat for you to complete. We are eager to get your thoughts on how we can improve and the kind of content that you would like to see moving forward. We're also inviting folks to submit their interest in becoming a DataBytes speaker. We have our event lined up for December, so we're all set for this year. But if you're interested in presenting in 2024, please do take a moment to complete that interest form. Next slide, please. And I would love to invite all of you to attend our career panel. Our fall career panel will take place next Tuesday at 5 p.m., featuring our moderator, Dr. Deborah Stroman, and a handful of folks from Pfizer, Bank of America, Alex Partners, and Renzi. We have a wide swath of folks working in the data science space, and I think it's going to be a really interesting opportunity to learn about their current work as well as their career journeys that have brought them to where they are today. So I hope you'll be able to spread the word about that event next week. We would love to have you join us. Final slide. This is a little bit of information, a little sneak preview for, excuse me, for our December DataBytes event featuring Christopher Lamb with Epistemi. This is going to be addressing causal AI, the key to high stakes decision making. And many of you might remember Chris from our June DataBytes event. He actually had so much content to share that we have invited him back for sort of a part two, a round two for his presentation. And we do encourage you to join and find your colleagues who might be interested in this really fascinating perspective. But that is all we have for today. And I do just want to say thank you again to Talya. It has been such a pleasure to get to know you and really appreciate you sharing your work here with all of us. And thanks to all of you who have taken this hour out of your day to join us. Hope you've enjoyed yourselves. Please take a moment to complete the evaluation. And thanks so much, everyone. Take care. Have a great day. Bye-bye.
You.
Thanks so much, Talya. Bye.
Bye.